Welcome, everybody. I was watching y'all chat earlier, cracking me up. Welcome, welcome, welcome. Yay. We're going to revel in the moment, right? Hey, Tina. I got to bring her up. She's backstage. Kathy's back. Can y'all hear me? I'm working from my laptop today. I've had, I've had a whole 2 days of no internet at all. Talk about first world problems, right? Like no internet, not even on our phones. It was SOS. It said SOS, literally. Okay, good. All right, I'm gonna bring KJ up. 1, 2, 3. Hey, girl. Hey,
Is somebody going to be doing any reveling today?
that's what we do here in Louisiana. We revel.
Are we going to kind of soak into this moment all of what we've been talking about for the last freaking couple of years, and we finally get something nailed down?
Finally, it's like trying to nail Jello to a tree. Finally, huh? I mean, I don't even know the details because I was just getting bits and pieces from y'all. And I was like, oh, okay. I can't multitask. We know this.
Well, I do think it's very interesting that the date that has been approved is April 3rd of 2023. What does that remind you of?
Joseph Ryan, when he was discovered in his apartment, deceased. That's what it reminds me of. First thing,
Can you believe that?
just saying, shit happens for a reason.
I mean,
You know,
he kind of got lost in all this, and now it's almost like, I don't know if you
it's a
want to.
package deal to me. That's a package.
He hasn't been discussed as much on my part, and I purposely did that because I didn't have any personal
Right.
empirical evidence of anything, and so I felt like I needed to focus on the actual
Hmm.
indictment itself and the people that were involved. And of course, that
Right.
your family means everything to everyone on here. And so I know you love Tammy and Joe and and all that, but I'm just saying it's just something that we've all been waiting with bated breath, basically. And many said October, and I was all downtrodden about it. And just to hear the news, it
Yeah.
just
It's it's good. It's good news. Um Finally, like, okay, finally. Good news. They're going to freaking trial, you know. I talked to mom. Well, not really. Like I said, I've been texting kind of. I had to turn my notifications off so I could focus. Yeah, I talked to Larry. Well, them. When I say mom, it's mom and Larry. They're interchangeable. But mom said okay, she put new trial date 4/3/23 and bunch of hands in the air, bunch of her emoji hands. And I was like, "Happy early birthday for Larry and KJ. I'm going to go live soon to share the audio," which Eric I just emailed. I mean, I just sent him my emails for him to send it to my email. Oh my gosh. And um so I'll have the audio. I haven't heard it yet. I don't know if anybody has. I know that Chad and
Eric is
Lori,
Eric is
Chad,
just incredible, don't you think?
he
Eric
is awesome.
doesn't he doesn't want any credit, but he
None,
deserves
nothing.
all the credit in the world.
I know he won't though, but that's till I meet him in person. I can't. I mean, Jen's the same way. I mean, you can't. I try, and where I come from, when whenever like, and I mean, it's not bad, but I was just raised this way. My mama is like this. She would, I would do something for her or whatever, and she would, give me money, and I'd be like, "No, mama, it's okay. No, no," and she would get mad. You don't do that to an old coon ass lady. You don't turn that down, like I did it because I loved her, you know? And
Well,
anyways,
Eric deserves a lot of credit for a lot of things,
and
and
he won't take it.
that's true. But we all love Big E. We love
We
Eric.
do.
I hope y'all always know
Yeah.
there are people that are working in the background, specifically Mama Bear,
Mama Bear, the
Jen,
mods, Leanne Ferguson, Beach Bum is our new mod, Trace on the Case,
Jennifer.
Jennifer, and then KJ's in the background. Well, she's you are my legal analyst.
Well, I'm not much of one, but I'll tell you this right now. The sources say, and I don't usually say something the sources say unless I'm pretty sure that this is fact. And that is that Chad Daybell was at that hearing today, but he didn't stay the whole hearing. He left beforehand, and it was a source that said they were looking at each other. And the
Mom,
first thing that popped in my head is he probably gave her that coded bullshit priesthood look and wants her to dang fall on their sword, the thing
yeah,
they created.
yeah. As he throws her under the figurative bus or whatever, Mom said, so I text her back and I was like, "Happy early birthday to Larry, going soon live." Da da da. We're gonna discuss and revel a bit. That's the day they found Joe. I told her, and I was like crazy. And then Mom said, I heard they kept looking at each other during the hearing. Didn't realize they'd be there. Don't think they've seen each other in person since she was arrested." And I was like, no, that was the first time. And I said, I haven't been able to read, only getting feedback from everybody. um,
Well, I take Kay's word over most anybody, and I'll tell you this right now: she's right, but you think about it. Lori and Chad both have to have seen each other on TV. But the time that Lori was up in the mental health facility, she was watching all the hearings, and there's a big difference. And Kay brings that out that they were face to face today. And I'd give anything in this world if the cameras hadn't been taken out of that courthouse. But we're just
mhm.
going to have to trust that,
We're going to
you
sign
know,
that petition.
we'll see it at the trial. We will see what we need to see at the trial. And I'm just going to say this while I'm thinking about it. I'm going to open up, and I hope Kay and Larry will hear this, and you, Chris, as well. I'm opening up a $80 bottle of wine this evening.
Woohoo, I'm
After I
going. I'll
get
be
done,
there in a minute,
I'm
girl.
I'm going to propose a toast to your Louisiana family, and I'm gonna be so thankful. We've all of us have been so just basically holding our breath. You've held your breath longer than any of us, over 3 years.
Still holding it. 4, almost 4.
Yeah, but you can breathe out now because,
uh,
and don't let any of these naysayers say, well, that could be moved back. That could be
it
moved back.
can. I mean, that's reality. I'm a realist. I mean,
Well,
that's why I don't get too
I
excited. I'm like, okay, good. There's a goal, there's something to focus on. When
just
it's
let,
up in the air like that, I don't know.
we got to
Mm,
keep this in mind. Judge Boyce said it when he had his hearing with John Pryor. He said, it's a big deal to have to get all of that facility over in Ada County taken care of, get all the,
yeah.
security. We've got to pick a jury, do all this stuff. And if he's going to set this date, you can be damn sure that we're going to have that trial on April 3rd of 2023.
Booyah. Welcome
That's
home
my
to
prediction.
Cleveland.
I believe it.
Mhm.
Y'all know I've been wrong sometime, but I'm telling you now, he's made it clear how hard this is going to be with a change of venue. And he's
Yeah.
going to do it to it.
And
And I'm
have you guys
proud of Judge Boyce. I'm
yeah,
proud of
I'm sorry. My microphone must be working really good or something. I don't know. It cut you out. Um, yeah, I agree with you. Um, what was I gonna say though? Oh yeah. I mean, and did y'all see like they did news stories or whatever on the preparations for Boise for the courthouse there, and I mean, so they were doing all this work, and all that's going into this. There's a lot into this.
it
There's
really is.
money to be made, y'all. I'm just saying.
Great
And I
point.
mean, it's money. I don't care. At the end of the day, at the end of the week, at the end of my life, it's gonna be money, right? It's I'm just saying, money. Um, and that's kind of why I wanted, like, up to Rexburg, but I wish it could have been there. The trial would be held there, but I get it. I understand. But if anybody deserves the income, it's the great people of Rexburg and Fremont County, and
Well,
they
I
deserve
think
it.
we've got a mixed bag on here. I think, like Beth Serrano says, Pryor will get it delayed again because he is going to have to say Chad is broke and needs a public defender. But then you have someone like, on here where they're talking about hello to everyone coming in, says Lynn. Lori has
Mhm.
not waived a speedy trial, says words matter. So you got all these different views coming in right now, perspectives, whether they're being specific about the trial
Mhm.
date, whether they're talking about, hey, let's all get together. We're all in this. We're going to do it. We're going to talk about it. And I'll tell you something right now. I bet Chad's ass was puckering. I bet it was puckering sitting by that damn hussy. You can
Right?
hear of it.
Good. I'm so glad. Didn't get all all over again. She was throwing some eyes at him. And I mean, just to see any kind of expression besides this, you know, I'd probably fall out. And yes, I am going to the trial. That's why I put that there, Roxy Cole. Yes, I'm going to the trial. We'll be there every day that I can physically, mentally, spiritually, all the leaves, financially be
Yeah,
there.
well, that's a good point because again, this goes back to we had an original January date. We all started saying, let's start supporting you monetarily towards the trial. This is only a few months later from the actual original trial.
Yeah.
So we've got to step up our game, do what we can out of the kindness of our heart to a victim's family member, which is you, and really,
I
not just
mean,
sit back and watch the whole drama of it or get
I
entertainment out of it. We're talking about making a real difference. That's what I'm talking about. If anyone on here who can give monetarily or wants to go to the merchandise shop on difficult research,
yeah.
please, y'all. Everyone's being transparent on here. She's on a fixed income, her and Jason's getting through his health problems. We've got to do what we can to come together for her. We want to look back over this when this case is adjudicated and say we did the very best we could for the victim's family. Okay, that's my view anyway.
Thank you. I mean, it sucks. I mean, it really does suck when you really think about it from my perspective. It's like, okay, Jason just had strokes, right? And then went back he had all those, a month of hospital, right? And near death experiences. Thank you, Sand, Willow, for always coming through. You always
I'm
do here. I mean, whether it's monetary or not, you're always here. And I thank you for that.
It's just incredible. I
I
mean,
really do.
I can't help but feel this swelling in my heart every time. It makes me so feel so very humbled
Me
that people
too.
want to step up. I mean, I do what I can as well, but I'm just telling y'all now. One day I'm going to look back on this and I'm going to remain friends with Cresha and her family. I'm not, this isn't about true crime.
Right.
This is about a community built out of love.
That's it. It's a just us. It's like free counseling, not free. Well, it's not free, but it's an outlet for me to share my perspective, to share my feelings, to share what it's like from my perspective. That's my JJ was my brother's baby boy, his only son, his only child. And when my uncle Charles and my aunt Lori, Aunt Satan, adopted JJ, that kind of took me away. Like, I didn't get to play the aunt role. I've always envisioned being an aunt, right? It makes me want to cry. But I mean, because I love other people's kids. Just picking. But I'm just saying, just something you always think about. But then, he hasn't had any more. I don't think, JJ would be 10. Um, it's just, It is what it is. And so just to watch that, my uncle, he was brutally murdered, just sucker punched. Thank you, fish face 123 is them, and I don't remember the name of the other one. Thank you.
Uh,
But
excuse
I
me.
want to be there. I see how this rips not just me apart. I'm trying to be strong for my parents, my brother. This is my effing family. This is my life. She and Chad, they effed with the wrong bitch. Okay?
Tell you
I'm
what, there
saying.
ain't nobody stronger than the Louisiana woman I know you are.
And I'm nice. I'm
And
being nice.
subject, but I've got to ask it. Do you have another way to donate that don't take 30%? Says one man's trash.
Yeah. I have Venmo, which is at Kresha K, or um I can't really see. Okay, and there's, yeah, Leanne just put the PayPal. Um those are the easiest ways. Like they're just clean line. I did download a Cash App or whatever, but it freaked me out, and so I offloaded it. I was like, no, I'm good. um, but anyways, yeah, there's other ways. Just you being here, everybody being here, that means the world to me. Um, I know you guys have been like the biggest support. Thank you, Ron. He's so sweet. For my family, Mom has said it. Larry has said it. I am here. Y'all are here. We do this every week, whether there's any movement or not. There's tons to talk about. Trust me, tons. I mean,
Oh
and
my
I'm just
goodness.
now getting into the.
Can you
I'm just
imagine what
now
we're going
getting
to
into
get
it.
into here? On your channel, Difficult Research, can you imagine what it's going to be like within the next couple of months?
Gonna
There
be
are
nice
pretrial motions that are going to be slapped down. There's going to be conferences. There are going to be all kinds of things to
afterwards.
keep everyone busy. And then, y'all,
Home.
if you're not getting this trial from Cresha K. Easton's point of view, being a victim's family member, and y'all know I'm right, you're going. I'm telling you, there ain't nowhere on YouTube or on any social media platform that's going to give you this real. I mean, we're talking a real victim's family member doing what she thinks,
It's
her
helpful.
feelings, her. Yeah, and there's never going to be another Cresha K. Easton in the world, just like there's
Revel
never
about
going to
that.
be another one of y'all.
Right. You're the only you're ever gonna be. I tell that to my kids, and they're like, it really sinks in, and it's really think about that. You're the only you're ever gonna be. There's ever gonna be. That's pretty unique. We
Well,
were the fastest swimmer.
me
Just
and
kidding.
everybody, I'm humbled to be here. Everyone else is humbled to be here. But I'm gonna tell you what, y'all, they didn't talk nothing about this motion hearing today as well. Because remember, I told some of y'all on KJ and the Ray, I said the transport order, Lori's going to be there. It shows they did service for Chad. But last time they did that, though, he didn't show up because remember, he didn't want to be there by her. Well, he was there today and he had to be there today because you know why? John Pryor knew they were setting a secure, permanent trial date for this, and Chad Daybell had to be there. They might as well get used to each other. They might as well look at each other because it ain't going to be about the Johnson anymore. It's not going to be about James and Elena anymore. It's going to be
James,
like, you are going down.
y'all, James the Lust. That's what I call him. I've been wanting to tell y'all that. James the Lust, not James the Just. Just just saying.
Well,
Ah.
take a look at his queen now. He can take a look at his queen now and realize that
Mhm.
she bought his shit, excuse my French, y'all, hook, line, and sinker. Well, nobody's going to believe a dang word neither one of them are going to say in this trial, even if they both get on the stand, which is highly doubtful. But the evidence is going to show quite clearly that Chad Daybell and her both were even Steven. They were the king and queen, the prophet and the prophetess, however you want to look at it. They're going down.
Yeah, I right there with you. Thank you so much for your donation, daughter of Scotland, Scotland in the house. Thank you so much.
And just
Um,
and Willis says, it's going to be bad. It's going to be bad for them.
And I do plan on going live. I just don't know how I will feel the particular day. You know, I'm not a fortune. I'm not a visionary woman. I mean, it's gonna take a toll. It's gonna be an emotional drain, roller coaster, but I'm gonna do my best. Y'all know
And
that
you
I
know,
like to
oh,
share.
it might be an emotional drain on you,
Mhm.
Crescia, but I'll tell you one damn thing. You, Larry, Kay, sitting in that courtroom, you're talking about the
Yep.
spirit of all these loved ones of yours are going to be there in spirit with you. We're all going to be there for you. And
Yep.
it's going to knock Chad and Lori out of their chairs. Not literally, but you know what I mean.
Oh, yeah. I'm sorry. I just pushed a button and said, "Oop." Sorry. Probably messing with Kathy. I'm on my laptop, so I gotta go get something to drink. You want to
Yeah,
take
well,
over for a
AJ
second?
said, AJ on here says, I wish the cameras would be there when Chad turns red when they say loin fire in court.
I do.
And that's a good point, AJ, because there's going to be a lot of stuff laid out there in this trial about Chad and Lori's ridiculous crap and what they did and what they thought was more important than the lives of these children, the lives of Charles Vallow, the life of Tammy. And they're going to have to see how stupid and silly they were to do what they did. And everyone's going to look at them and think, you know what? This is just one little incident that goes that there's other people out in the world that believe in this crap. And I'm gonna tell you what, one of my biggest prayers is that this trial will teach these people out here that you want to go and do this stuff, you want to do this is what's going to happen to you. Because make myself clear, I will, KJ will. If Lori wanted to be even Steven with Chad Daybell, if he gets the death penalty, she should get the death penalty. Now, we know that she's been in a mental hospital, and that's a mitigating factor against her getting the death penalty. But I'm telling you now, they both deserve death row, in my view. That's just the way I see it.
Roger that. Okay, I had to get something to drink. I'm thirsty, like Lori.
Well,
No.
the emotions will come out on that audio, and it's my opinion. The bill of particulars, motion to compel, um, the motion for the constitutionality of the death penalty and all that. Archie has to file that. Archie has to, when he files a motion like that, it's got to be heard whether he believes it or not, and it's going to fall flat on their face because any of those, uh, they've already been answered by the state, and the trial date has been set today. And that's one thing that I felt was more important about today than anything else, was that they said it was not only a motion hearing but a scheduling conference. And I knew then, I'm like, deep in my heart, I didn't want to say it out loud because I didn't want to be wrong.
Order, you ready?
Oh, y'all want to hear the audio? Go
Go on the
ahead.
record, cases CR 2221-1624.
I don't know if y'all want to
State
listen
versus.
now
Yes,
or y'all
yes,
do. Okay.
yes.
All right. Well, I'm gonna mute. Well, I can't mute myself, but I want to make sure y'all can hear it. So I'm gonna turn it on, and then y'all tell me if it's too loud or not. Okay.
Noreen Vallow Daybell.
It's 65 minutes long, also. So it's gonna be all right. Ready? Like to hear it? Here it goes.
She's here represented by counsel Mr. Archibald and Mr. Thomas. Also, case CR 2221-1623, State versus Chad Guy Daybell, who is here present, represented by his attorney, John Pryor. We have a scheduling conference scheduled for this morning, as well as some motions that were set. Before we get started, the court would note that the attendance of the public in this hearing is subject to the rule and order governing courtroom conduct. There's just a couple of issues out of that order that people have been advised of that I want to reiterate as it relates to cell phones. So the order indicates, and you need to comply with that, that all cell phones must be silenced or turned off at all times while in the courtroom. And if a cell phone or other electronic device rings or beeps or is found to be in use during the court, it would be confiscated by the marshal, and no talking on a cell phone in the courtroom. Also, as it relates to other electronic devices, Those in attendance may not or may utilize computers, laptops, and other devices for the purpose only of note-taking. All right, that's what we're talking about. Someone's phone just went off. So the phones cannot be used or other devices to do anything other than note-taking, can't be used to record or transmit any sounds or images in or from the courtroom. And if electronic device is capable of recording or transmitting sounds or images, those functions are not to be activated while the electronic device is in the courtroom. In violation of that rule may result in confiscation of the device. So I would ask everyone to comply with that. Going forward then, the first matter we're going to take up at this time is our scheduling conference. The court previously had trial in this case scheduled in January. However, due to complications that occurred in the case, we were required to vacate that trial setting. The parties are now all back and present. There's no stay requiring us to further postpone trials. So the court at this time needs to get the trial scheduled. A little bit of background on that also, as council's fully aware, this trial is going to occur in Ada County. As such, there are, we have to make, with Ada County, cooperate with them in their policies and availability and scheduling trial, which the court has been in contact with the administrative district judge of Ada County to confirm certain timeframes when this trial would take place. The trial was originally scheduled to be a 10-week trial, and I believe council still indicates that's the time that would be needed. And given the length of the trial, we do have to work with Ada County in certain dates, and there are certain times of the year that simply don't work there. So I will note that I had a discussion with council, I think it might have been a couple of weeks ago, about some potential timeframes, and I have further talked to Ada County in regards to those timeframes. So at this time then, the matter does need to be set on the trial calendar, and what I'd like to do is just hear from council on recommendations as to when you think trial ought to be set. I'll note that there is a joinder of trials still in effect, and there has not been any waiver of speedy trial from Ms. Vallow Daybell in her case, which the court must consider also in making a determination. So for the scheduling conference then, I'm going to start with the state, and the state's aware of some of the timeframes that have been proposed, and I'd like to hear from the state when you think we ought to have this trial scheduled. So who's going to be commenting for the state? All right, Ms. Rawlings, if you'd please make your recommendations.
Thank you, Your Honor. The state's position has always been that these matters are properly joined for trial. This court has also found that they are properly joined for trial, and therefore we are requesting the court select a joint trial date, which takes into account both defendants' constitutional rights. While the state recognizes that Mr. Daybell has waived speedy trial and requested a continuance, and in fact, the state had not objected to that. The state also recognizes that Ms. Vallow Daybell has not waived speedy trial, as the court noted. So these constitutional concerns will need to be addressed. Accordingly, we would just let the court know that the state is ready to proceed to trial, and we will comply with any trial setting the court sets for the parties after taking into consideration these constitutional issues and other logistical details. The court had previously mentioned the possibility of available trial dates in April, June, and October. And again, although we will be ready to proceed with any trial date the court selects with regard to a potential October trial setting, we just wanted to bring to the court's attention some concerns that we had considered recently. For the October trial setting, there are some concerns with the very high possibility that we would run into the holiday season. The 10 weeks proposed by the parties, I think initially we did not factor in time for deliberation or the penalty phase. And so while the process could take less than 10 weeks, it could also take longer depending on how we conduct voir dire and other unforeseen delays that could occur in trial. So we're just concerned about possibly running into, having to take a break around Thanksgiving and then depending on how long it takes to get to the penalty phase running into further holidays.
Girl, speak up.
So taking into account that timeline and the requirement, the statutory requirement, that the jury be sequestered for deliberations in the penalty phase, and the potential, the state has filed a request that the jury may be sequestered for the duration of the trial. The state would ask the court, if you're looking at an October trial date, to consider beginning jury selection in either mid-August or September, just so we avoid some of those concerns. I think with regard to any outstanding discovery issues, the state had provided an email to the court and parties previously, and we'll just note that at least one of the 3 items that was outstanding has been completed. We will have an idea in the next, I think, 3 weeks from the state lab with regard to outstanding issues for testing there. And then I think there's one other item that was mentioned in that email that we anticipate having a report on shortly as well. In addition, we would just note that as part of any scheduling order, the court will impose a discovery deadline, and the state intends to comply with that. If there are any concerns related to outstanding discovery that's not provided within that deadline, then I think the parties could raise those with the court, and they have appropriate remedies under the law. Thank you.
All right, thank you, Ms. Rawlings.
Sound like she was talking in a circle.
All right, Mr. Pryor, let's move on to your recommendations. When do you think would be an appropriate time for trial to be scheduled in this case?
Judge, seeing the council brought up the issue of the joinder of the trials, it's still my position, Mr. Daybell's position, that these cases should not be tried together. We've sought in the past to have them severed. Obviously, the court disagrees with my analysis, but our position is still the same, that in order to adequately prepare for this trial, we still need a significant amount of time. And when I mean a significant amount of time, I mean a significant amount of time. One of the concerns I have is that if we had kept the original trial setting, January 9th, I believe today is the 8th of December, and the jury instructions would have been due, and a number of other items would have been due. And yet, this morning, Mr. Wood personally handed me a thumb drive with 115 items of discovery on them. Now, I did get a chance to look at an addendum, and some of these items of discovery are significant. And it's going to take a significant amount of time for not only myself, but my investigative team to go through all of those and determine what we have to do and what steps I have to take to be prepared for trial. Now, when I made a representation to the court that I could be ready for trial on the 9th, the court did that, yes. But then suddenly new discovery comes out, 115 items. I'm going to have to provide those to Mr. Daybell. He's going to have time to go through those. I'm going to have time to go through those. I'm going to have time to determine whether or not I need to seek any motions as it relates to this. I have no idea as of today what's in there. In addition, Judge, I understand that opposing counsel, Mr. Thomas and Mr. Archibald are seeking a motion to compel. At some point, I'll be joining them in that and seeking the same information that they're seeking today. But in addition to that, Judge, I have at least, I believe, 60 to 70 other items of discovery that have not been turned over to me at this point. I don't have those items, and those are items that I have a significant interest in, and I will absolutely need. Now, I'm creeping up on 2 years on this thing.
Oh.
And it blows my mind that after 2 years, I can't get the simplest items of discovery in a case. And I would think this would be a priority to the state. And yet they're not providing me this information. And I want this information.
No, I need.
In addition, at the last hearing, I believe last month, I sought a transcript of a grand jury proceeding. And there was opposition by the state to have them provide that to me initially. They initially then conceded that, oh yes, I do get it. But to date, I don't have that grand jury transcript, and I have no idea when I'm going to get it. And just because it's handed to me doesn't mean I have time that day to go over the transcript and evaluate it. Because once I get the transcript, I'm going to have to evaluate what witnesses I need to talk to, what information I need to convey, and then I'm going to need to sit down with Mr. Daybell and go over that transcript and discuss, how that affects this case. So it isn't as simple as them dropping something off to me and saying, here you go, you've got it, let's roll. It doesn't work that way, and they don't get to do that. They need to afford me adequate time to prepare. And it's not my fault. Regardless, it's not my fault that I don't have all the information. And I'm not putting specific blame on this prosecutor's office. I don't know what law enforcement's doing and how, what their procedure is to get this information to them. But at this point, I don't have it. So my position is simply this: at the earliest, I'll be ready in October, given what they're giving to me now. And unless they can tell me when I'm getting the transcript, and counsel was very careful with her words today. She said, well, we should get some information in about 3 weeks as to where we might be in terms of the DNA evidence. Well, that doesn't mean they're going to get me the DNA evidence in 3 weeks. And I've been down this road with them before. That means they're going to get some information. And then when are they going to decide to turn that over to me, Judge? Are they going to turn it over to me in May or June so that I don't have any time to look at it? I want to make sure that after several months from now, I can guarantee I have all of the information. And then at that point, we can start the process of getting ready for the trial. But if this is the way this is going to work, if this slow walking or this feeding me the discovery in this slow manner is the way this is going to operate, then I need a significant amount of time to take a look at this thing and be able to prepare. And it's
and a flask of whiskey.
So, Judge, I am strongly asking for October. If the court can go beyond October, my preference is to start the following year.
All right, thank you, Mr. Pryor.
The following year.
Let's see, Mr. Archibald, will you be addressing the court today?
Yes. May I remain seated?
You may, Mr. Archibald.
Please.
For purposes of trial, my client has not waived her speedy trial. The court has been careful to acknowledge that right. And so by our calculation, we cannot agree to anything past February 21st of 2023. And here's how we get there. She, when the grand jury indictment initially came out, she was hospitalized and returned from her commitment in April of 2022. So her right to a speedy trial started in April of 2022. So 6 months by statute, by court rule, and by our Constitution of the United States and the Constitution of the state of Idaho have been interpreted that a speedy trial means 6 months from arraignment. So for the 6 months from arraignment would put us at October of 2022. The court initially gave her a trial setting and was respectful of my client's rights to a speedy trial. So the court set it for October of 2022, and we appreciated that. A motion to continue is then filed by the state asking for additional time. And the court found good cause to postpone the October 22 court date and moved it to January of 23. In the interim, our case was stayed or told for approximately 6 weeks or 41 days. And so when a case is stayed or told, that adds to the speedy trial time under our case law.
And that's what you asked for, Archie.
Date of
to toll it.
21 of 2023, the court needs to set our client's jury trial on or before that time. If it's after that time, then we believe her speedy trial rights will have been violated and we'll file a motion to dismiss the case.
The victims are
So
violated.
that's our position, Your Honor.
So
All
sorry.
right, thank you, Mr. Archibald. All right, well, the court has considered the differing requests of counsel here. I'm obviously familiar with the prior proceedings in this case. There was previously a motion to continue by the state, and the court issued a memorandum decision and order granting the state's motion to continue the trial in an order issued May 26th of 2022. And in that order went through some factors that the court considers in determining delay and whether it can be justified when the right to a speedy trial has been asserted. There are factors in a case called Barker versus Wingo that the court cited to. Those factors still apply. The test analyzes a speedy trial claim pursuant to 4 factors. That includes the length of the delay, the reason for the delay, the defendant's assertion of the right, and prejudice to the defendant. And then that prejudice factor actually has 3 separate prongs. And under the prejudice factor, the court has to look at the first prong to prevent oppressive pretrial incarceration, part B to minimize anxiety and concern of the accused, and C to limit the possibility that the defense will be impaired. So looking at some of the timeframes here, by the calculations I have, this Vallow's been in custody approximately 2 years and 10 months or 1,022 days since arrest.
Yay.
If I have to consider that, obviously. Mr. Daybell has waived his right to a speedy trial and is requesting a trial in late 2023 or early 2024. He's been in custody 2.5 years by my calculation, 912 days as of today. And I do consider there were cases that preceded these 2 cases. We had case CR 22-2838 and 22-2755, which were sort of precursors to these cases. When I look at the time frames, while those cases were ultimately dismissed after the indictments that were filed in this case, the defendants both were taken into custody and incarcerated on warrants in those cases and have remained in custody. And I think notably, those what I'll call precursor cases arose out of many of the same facts and circumstances which led to the later charges in the indictment. Obviously, additional evidence was developed during the time leading to the now much more serious charges that have been filed through the indictment in this case. However, the practical reality is those timeframes I just mentioned in terms of length of incarceration gives great concern to me when I have a defendant who has absolutely and unequivocally never waived her right to speedy trial, either in this case or in the preceding 838 case. And I have to consider that with the factors.
She's a bitch.
I'm not going to go through a full analysis of speedy trial today. If that comes in the form of a motion, as Mr. Archibald indicates it will, then we'll take that up in further detail. However, obviously the court has to consider that in trial setting in determining an appropriate time to set trial. I have consulted extensively with Ada County in terms of practical times of when they tell us this could happen. And what I've learned through that and have determined is they would be able at the earliest time to commence trial at the beginning of April, which would be April 3rd. And when I consider the other factors that are weighed out here, I've considered the concerns raised by Mr. Pryor on behalf of his client with discovery outstanding. Clearly that is a concern, and discovery needs to be completed to be have an opportunity for counsel to prepare for trial.
You're fine, AJ.
The DNA issue, which keeps coming up, I would note, that was first raised before this court in April of 2021. So by the time we would get to trial, that's at least been an issue that's been known to all the parties. It will have been for 2 years by the time we reach trial. And at some point, while those concerns have to be factored in, We have to move a case forward when we've got people that are in custody, and where this has been joined for trial and on prior rulings will remain joined for trial. I do find that I cannot justify at this point setting the trial beyond as soon as possible time we could accommodate that because of the assertion of speedy trial right by Ms. Vallow Daybell. So the court is going to schedule trial for April 3rd, and that will be the start date of when the court would like to present or have essentially the trial start. I think it's feasible that the process of using jury questionnaires and bringing jurors in late in March in order to get the jury questionnaire process started should probably take place, so we can look at actually trying to start trial in April. But in terms of the availability of their resources in Ada, the trial can go on April 3rd. And so I'm going to set that as the date for the commencement of trial. We'll set that out for a 10-week trial. Council, typically I set a pretrial conference also, but we're going to issue a specific scheduling order that will include a pretrial conference date. Clearly there's additional litigation that needs to take place in the case before trial commences. Court will reach out to counsel and make available multiple days for motions hearings in anticipation of pretrial motions that will be filed. And that's the date we will start the trial at this point. So in lieu of asking if there's any questions on that, I think that's just a pretty clear answer for everyone. That's when trial is going to begin in the case and will be scheduled. I've considered all those concerns, so we'll submit a scheduling order in the case that will provide other deadlines and times when things need to be filed pre-trial. We'll also set forth some scheduling in terms of pre-trial motions. So that's the ruling on the scheduling conference for today. All right, at this point then,
Oh, I can hear
we
you.
do have additional motion hearings, and those are only in the 1624 case with Mrs. Vallow Daybell. So at this point, we are going to have Mr. Daybell excused from the courtroom by the marshals if the
He don't get to be with his queen.
security takes care of that issue. We'll then move on in a moment to our next motion.
Archie needs to, let Lori give Chatty Boy a hug goodbye.
Right. Wink, wink.
And John Pryor needs to go take a swig off that flask in the back room for a few minutes.
I love Lil Brand said. It sounds like he's swinging around. Like they're orbiting, around the damn microphone.
If you think about it,
Next issue we'll take up is a
Lori.
motion to compel that was filed by
It's
the
because of Lori we're getting the trial in April.
Second, courts received a copy of the motion and reviewed that. The state filed a response to the motion to compel on December 1st. I reviewed the response also. Mr. Thomas, are you arguing the motion to compel?
I am, Your Honor.
Okay, if you'd like to proceed with
Your Honor, I would just ask very quickly, I apologize for interrupting. Mr. Pryor just represented that he's going to file an identical motion versus a judicial economy. The state would ask for a continuance, so we can argue this all at once.
On the motion to compel?
On the motion to compel.
All right, there's a request to continue then, Mr. Thomas.
We would object to that, Judge. The motion to compel, we're less than 4 months away from trial, and the state has been continuously stalling and dragging things on. I'm prepared to go forward. I want to go forward. I think the court needs to make an order today.
All right, the court will deny the motion to continue the scheduled motion to compel. Mr. Thomas, you can proceed with argument.
Thank you, Your Honor. Would the court prefer for me to sit or stand?
I think it does work best if you remain seated for the microphones.
Very good, Your Honor.
I don't know.
The motion to compel today was very narrow. We specifically asked for information on witnesses pursuant to rule, I know court rule, criminal rule 16b6. That specific rule has not been complied with. I know the state mentioned in their motion to compel their response The state has complied with this requirement and will continue to do so. I would just note for the court's own edification, the state has not complied with Rule 16 in the least. Rule 16 requires that they send to us a list of witnesses, which they have done in an addendum months and months ago. I have asked for names and addresses as required by Rule 16. The state has given me names of 115 witnesses that they are proposed witnesses that they put on their witness list. There are no addresses on those. There's no way for me to track these people down. So the state has failed to comply with the basics of Rule 16, but we're specifically asking that Rule 16b6 be complied with, and the state indicates in their response that there is nothing in Rule 16 which requires the state to disclose trial or hearing preparation with witnesses. And I would just read from Rule 16b6 just so that I can get it on the record for appellate purposes if I need. It says, on written request of the defendant, the prosecuting attorney must furnish the defendant a written list of names and addresses of all persons having knowledge or relevant facts who may be called by the state as witnesses at trial. I just went through that. The state has not complied with that. It goes on further and says, the prosecuting attorney must also furnish on written request, which I have given, the statements made by prosecution witnesses or prospective prosecution witnesses to the prosecuting attorney or the prosecuting attorney's agents or any official involved in the investigation of the case, unless a protective order is issued as provided in subsection L. And subsection L of Rule 16 is all about protective orders, but I'm not aware of any protective orders that have been issued. And the prosecuting attorney has not complied with Rule 16b6. We've specifically requested, and I'm only going to mention three because those are the ones that I have specific knowledge of that I know that the state has met with because I've had conversations or someone on my team has had conversations with these people, those being Melanie Gibb,
You got a team.
Melanie Pulowski, and Zulema Pastinez.
Holy
The
shit.
state indicated that they have turned over everything with regards to these witnesses and with these investigations. They indicate in their brief and in
Mr. Thomas, just for purposes of the record here, would you mind repeating those names and
Oh, yeah.
provide a spelling on the last names if you don't mind?
Yeah, okay.
Sure. Melanie Gibb, Gibb, Melanie Pulowski, formerly Melanie Boudreau, Powlowski.
Y'all, Zuzu and Melanie P are going to be
Yeah,
witnesses for the state.
T-N-E-Z.
Yeah.
Thank you.
I
believe those are
I've been
correct
spelling her
spellings.
name wrong.
But what I'm getting at, Your Honor, is that the state's indicating that we are attempting to get their trial strategy or their work product. I can tell the court pursuant to Rule 16G, we are not trying to get their work product. And I would caution the state or the government to review Rule 16 with respect to exactly what work product is pursuant to the rule. The rule states that the prosecuting attorney must also furnish on request the statements made by the prosecution witnesses or prospective witnesses. We went through that. The order with respect to that does not delineate what witness statements were made for trial preparation, what witness statements were made for investigative purposes. They are witness statements. They are required to be turned over by the state. Now, Rule 16G indicates the prosecuting information that is not subject to disclosure, which is their work product, so to speak. It indicates under paragraph A, G1A, it says legal research or records, okay? They've not turned anything over. I understand that. That's their legal research. That's their work product. Then it goes B and C, correspondence or reports or memoranda to the extent that they contain opinions, theories, or conclusions of the prosecuting attorney, members of the prosecuting attorney's legal staff. Those are not, hey, we had a meeting with a client at some point during that meeting, I may have given some legal opinions or some legal theories, therefore they don't get that. That's not what the rule says.
You don't get
What the
that.
rule says is that
You're a piece of
the
shit.
reports, memoranda are to the extent that they contain opinions, theories, or conclusions. So they still have to turn over those meetings with those witnesses or potential witnesses. They may, pursuant to court rule, redact or extract the portions of those meetings that have opinions, conclusions, or theories of the prosecuting attorney. The rule is very clear as to what they need to turn over. That's everything. Their work product is not all encompassing. It's not a large portion of what the discovery is. And I think that the makers of the rule were specific in carving that out, because if you look at what the defense is not subject to disclosure, it's far more broad. Basically what they get is scientific and medical records. That's pretty much it. And so I would ask the court to require the state to turn over every witness encounter that they have. Apparently, I learned today that Mr. Pryor got under a previous court case involving Ms. Daybell, some emails from Melanie Gibb to Rob Wood and some emails back from Rob Wood to Melanie Gibb. Those were never turned over to us in this particular case, to my knowledge. I was stunned when I heard that those were ordered by the court in another case and that we still don't have them.
Sit down,
so I would ask the court to make sure that we have all of the statements given by the witnesses and prospective witnesses. Other than that, Your Honor, I have nothing.
Sit down, doughboy.
Is responding for the state?
I will, Your Honor.
All right, Mr. Wood, what's the state's response on the motion to compel?
Your Honor, the state has looked at Rule 16, and it doesn't say what Mr. Thomas says it says. Nothing in Rule 16 says that we have to give all dates and times of witness views or interaction. Nothing says that. It says statements of the witnesses. We have turned over those statements, and I want to be very specific on Melanie Gibb, Melanie Pulowski / Boudreaux or Zulema Pulowski or Zulema Pastenis. They have all that. The items he just mentioned, we've turned that over. And so the court can order it, and that's fine. We'll comply because we already have. But there is nothing that says
Gotta be literal.
that we have to turn over meetings. There's nothing that says we have to turn over interaction. We have to turn over statements. And so if we're in hearing prep or trial prep and we meet with a witness and they tell us nothing that's not new, nothing that hasn't been disclosed already, the state's position is that's not a statement. They've already received that information. It has always been our practice that if new information is given, it's disclosed.
Mr. Wood, of the address has been provided. That was a specific comment, and it is required under the rule.
I agree with that, Your Honor. I was under the impression they have, and we will double check if they have not. They will be. And okay. We don't object to an order on that at all. We agree that the rule states that. But other than that, Your Honor, we have complied with the request to turn over statements, so we will continue to do so. We understand what's at stake if we don't. We understand that the information that may be useful to us, if it hasn't been turned over, it doesn't get to get used at trial. So we understand it's in our best interest to turn it over. I would just note in that it's a little, that the state, and we haven't filed a motion to compel, we actually filed a motion for a request for discovery at the beginning of this case. No one's ever responded to that. And yet now they're saying that we're not responding. I think it's a little bit rich when they haven't even complied with the rules either, or haven't complied with the rule. I think there's some very false assertions made in their motion to compel. They're claiming positions taken by the state we've never taken. We addressed that in our response, so I won't go into that here. But again, we have complied with the rule. We will continue to comply with the rule. I think their request goes well beyond what Rule 16 requires.
All right, thank you, Mr.
Called him a
Wood.
liar.
May I-
Rebuttal, Mr. Thomas.
Yes, Your Honor. I would like to call a witness if that's okay with the court.
Oh, what the hell?
You may.
Your Honor, I'd like to call Brandon Hobbs to the stand.
Oh, I thought he said Pedro.
Who's Brandon Hobbs?
Board, please.
We're about to
You need
find
to
out.
pause once you
Google
get in
that
the
on
well
up.
here, and please raise your right hand, and I'll have you placed under oath.
My devices are used.
Kathy, tell us who Brandon Hobbs is.
I can't Google it.
Somebody on here. Go and Google it for us.
Your Honor, the state objects. There was no notice given of this.
Well, I'll tell you this, Mr. Thomas, the testimony is going to be limited to any rebuttal argument because you had your opportunity to present your motion. And if this witness is going into new items that don't relate to the response the state just argued, then I think it's outside of the scope. But if it's in a response to that, I don't know that there needs to be a requirement of a notice for witnesses at a hearing.
Thank you,
Somewhat unusual
Kathy.
with a motion to compel, but I'll just ask you to limit the scope of any inquiry to this witness to the
Yes.
state's response and
I've
not
been wanting to know
reopen
who that
things that
is.
you didn't raise.
I've
in
been
your
wanting to know who the
argument.
realtor
And I
is.
understand, Judge.
Ooh.
Mr. Hobbs has no idea he was going to even testify today.
Well,
It is only
Is
in
this
rebuttal.
the realtor that was with
Yep.
Chad and Lori and Alex and them out there trying to buy that property?
Charles,
Yep.
would you please state your full name and spell your last name for the record?
Yeah, Brandon R. Hobbs, HOBBs.
Oh yeah.
And Mr. Hobbs, you heard the argument today by the state indicating that they have turned over all discovery with regards to witness statements. Did you hear that?
I did.
Okay. And when you heard the three names that I specifically gave to the court, did that ring any bells with you?
They turned into
One or
toads.
two.
Okay.
Sorry.
So let's talk about Melanie Pulowski. You specifically met with her in the last several weeks. Is that right?
That's true.
And why is it that you met with her?
I was assisting our mitigation expert in Arizona with a multitude of interviews, and we met with her there.
But you met with her for a specific reason. We had you meet with her for a specific reason. Is that correct?
It is.
What is that? What was that reason?
It had to do with her having an interview or being called by the state and being met with by a special SSRA, I believe that's what it's called, FBI agent, Doug Hart.
And that was most recently?
Yes.
Okay. And when you were down there meeting with Ms. Pulowski, you had no idea that she had met with the state, or you'd found out that she had met with the state when? How much earlier?
A week or two?
Okay. So these interactions were ongoing with the state?
Pulowski?
Yes, with Ms. Pulaski and the state. Okay. And when you were, I believe when you were traveling on that specific trip, you also went to Ms. Pastina's home, is that correct?
Yes, sir.
And what happened at that time?
She was not home, so I got a hold of her and her attorney
And what was said at that time?
that they were in Rexburg, Idaho.
Objection hearsay.
Sustained.
Yeah, it's sustained.
Do you have specific knowledge as to interviews that were taking place with the state, with Ms. Zelema Pastinez in the last several weeks?
Yes.
Okay. Can you tell the court about what you know about that specific?
So within 2 or 3 days of leaving Arizona, I contacted Ms. Pestinez's attorney, Smith, and he told me that they had indeed been up there.
Objection hearsay.
That is sustained, and I'll strike the answer.
Did you meet with? Did you talk to Ms. Pastinez?
Yes.
What did she say?
Objection hearsay.
That's sustained again. That's clearly hearsay.
Your Honor, and I understand, the state is indicating that they have met Rule 16, and we are trying to inform the court that that is a blatant lie. And I don't like to call.
Objection. That's argument.
Yep.
It is argumentative, and I'll sustain that objection.
I agree
And
with Leanne.
Mr. Thomas, unless you show me a exception to the hearsay rules that would apply in this instance, is hearsay.
I object. No.
This is some serious shit, y'all.
Yeah. I can hear him whispering.
Your Honor, I'm actually not offering it for the truth of what was said. I'm offering it for the fact that there was a meeting between the state and Ms. Pastinez, and that the state is attempting to mislead the court by telling them that they did not have a meeting with Ms. Pastinez.
Your Honor, the state never said that.
I,
Mr. Thomas is going to make argument. He ought to base it on fact. I never said that we haven't met with that the state hasn't met with Mrs. Pastinez.
Understood, and I still will rule that is clearly calling for hearsay, and I don't find that to be an exception to the hearsay rule. I think it is offered exactly for the truth of the matter asserted, for you to establish this fact is what you're trying to do with the testimony. So that's the ruling on the objection.
All right, Your Honor, I have no further questions for Mr. Hobbs.
All right, any questions from the state?
Mr. Hobbs, have you reviewed the state's most recent discovery disclosure?
I did.
Okay. So you're aware that those reports are in there?
I am.
Okay. So the state has disclosed the reports of those meetings, haven't they?
Yes, we got those.
The state has disclosed those interviews, correct? Thank you. That's all.
All right, any
Damn.
questions, Mr. Thomas?
To Ms. Pastinez, we received that report.
To be clear, the one that I reviewed and the ones listed in the new thumb drive that I received yesterday that I believe
Who the hell is this guy? He's a realtor.
One that I am familiar with and can testify to would be the Pulowski.
Okay.
I have not seen the Pastinez one.
So you're saying that you've seen something saying that they've disclosed something with regards to Zulema Pastinez?
I have not seen anything with Ms. Pastinez.
Okay.
With Ms. Pulowski.
Okay.
And I will relook at that.
Nothing further.
All right, thank you. That'll conclude your testimony then, Mr. Hobbs. You can go ahead and return to the gallery.
Thank you, sir.
Sit in the corner.
Mr. Thomas, any further argument on the motion?
Yes, Your Honor. My argument is that there have been meetings with the state, and where the state says, they're playing this gamesmanship where they're trying to splice words and trying to say, hey, we had a meeting, but we didn't disclose anything, or we had a meeting, but they didn't say anything. Why would they? I don't understand why they would have Ms. Pastinez drive up here or fly up here with her attorney and meet with them and not say anything, and not have her say anything. That doesn't make any sense. And for the state to tell the judge, oh, we didn't say that we didn't have a meeting. We're just saying we've disclosed everything. And apparently they haven't.
Literalism.
So that's my argument.
All right.
I get it.
Well, the court has considered this motion to compel
Well,
based on
hey, Rowan.
comments from the state. The court is going to grant the motion to compel and enter an order. I'll let you know the scope of the order is essentially just going to mirror the language of Rule 16. Look for this 16B6, which has that requirement. There's been some evidence that part of that hasn't been complied with in terms of providing addresses. I don't have any other particular examples that were raised in the motion for me to make specific rulings on at this time. These three names have been provided. I'll issue the order granting the motion, and it'll essentially follow the rule that further compliance is necessary. In the future, I guess, Mr. Thomas, if you think the rule is being enforced again through an order, the order will be in place. And if you bring any specific instances to the court that you believe demonstrate a failure to comply with Rule 16B6, then the court will consider those on further motion. So that'll be the ruling of the court on the motion to compel. Any questions about that, Mr. Thomas?
My only comment is that we don't know what we don't have. And so it's up to the state to provide that. And the court's saying that they have to provide it, and they're saying that they don't. And so,
Well, if you don't know that they have
The
it, then
state
how do
has
you know
never
they're
said
keeping
we
something
don't
from
have to
you?
comply with Rule 16.
And I do agree with that. They didn't say they don't have to comply. They said they will comply. The order is going to say they have to comply. And that's what's before the court right now. I can't speculate about what I don't know that's not out there and order something specific that I don't have any specific facts on. So I'll rule on the facts that I have before me, and that's what the order will say. If you think the order needs to be enforced, then you'll have an opportunity to do that without need to seek another order.
Very good, Your Honor.
So that'll be the ruling. Any question on that ruling, Mr. Wood?
No, Your Honor, thank you.
All right. That'll conclude the motion to compel then. The next matter we have scheduled is a motion entitled Motion to Declare the Death Penalty Unconstitutional and to preclude its application in this case because empirical research has established that modern death penalty is as unguided, arbitrary, and capricious as the system of capital punishment struck down by Furman v. Georgia. Counsel, there was
Dream
some
on,
discussion
Alice.
for this.
Dream on, Alice.
Pryor indicated he would be filing a similar motion and that perhaps the parties could hear that in a joint hearing. At this time, let me ask from the defense, having considered that, does the defense wish to argue this today, or would you like to continue this to hear at a joint time as the other case?
Your Honor, Mr. Pryor did indicate this morning that he wanted to file similar motions on behalf of Chad Daybell that have been set for today. The motion to declare the death penalty unconstitutional and the motion to prevent death qualification of the jury. Mr. Pryor is going to file motions similar to those. Then it does make sense to hear those on the same day rather than hear him today and then hear him again from Mr. Pryor at our next hearing. So I'm, so long as we can get it rescheduled for our next law in motion, I'm okay with continuing those. That does make sense for judicial economy to have those heard at one time rather than on 2 days.
Yeah, it's unconstitutional to
Motion
murder
for
children.
Particulars has already been argued by Mr. Pryor, even though we filed ours first. But since our case was stayed, we couldn't argue it. And so, if the court wants some additional argument on our bill of particulars, perhaps we can at least clear up that issue, since the court has already ruled on Mr. Pryor's similar motion.
All right. From the state then, is there, well, it's the motion of the defendants. So in terms of rescheduling this, does the state have any objection to this matter being rescheduled for a joint hearing with the other case?
In terms of the death penalty motions, Judge,
Yes.
no, there's no objection to hearing them all at the same time.
All right. On the bill of particulars issue then, Mr. Archibald, that was filed but not noticed for today. What I would suggest then is maybe if it needs to be heard in your case, we schedule that at the same time as the other two capital motions that will be scheduled. I will get some scheduling, as I mentioned, to counsel, and obviously don't want to have a delay in hearing these motions that you've already noticed for today. So the court will allow those motions to be continued to be heard at a later date. I'm not prepared to schedule that at this time, but I'll reach out to counsel and we'll find a date we can set aside for further proceedings to hear those motions, including if you'd like an argument on the bill of particulars that you filed.
Your Honor, just for the record, the state was prepared to do bill of particulars. I recognize the court may not have that on the calendar today, but I think we had talked to defense counsel and we are under the impression it was going to be heard today.
Oh.
It's absolutely court and defense counsel's private, but we're ready if you want us to be.
Well, if you'd like to argue it, I didn't know that was scheduled for today. However, we have previously heard the motion. I'm familiar with the motion, and if you'd like to present argument on the motion today, we can use the time to do that.
Yes, I'm sorry, Your Honor. We did put that motion for a bill of particulars on our notice of hearing that was filed on November 23rd. So I'm sorry that got missed. But the court has already heard argument on that. Mr. Thomas would like to add some additional factors for the court to consider.
All right. If you'd give me just a moment, Mr. Thomas, if you could direct me to the date that that motion was filed in your case, if you happen to have that.
September 2nd of 2022.
Hey, Mom. Wake his ass up. Oh my God, you hear a pin drop. Oh, sorry, KJ.
Okay, I've located the motion. I would note I've previously reviewed the motion as well. So we'll move forward with oral argument on the motion then. As council just mentioned, it was filed in this case September 2nd, 2022. Mr. Thomas, if you'd like to present argument on the bill of particulars, you may.
Thank you.
I love you, Kay and Larry.
Remain seated if that's okay with the court.
Yes, thank you.
Thank you. All right. So basically, I know that the court's already heard Mr. Daybell's arguments, and we would echo all of those arguments. And I would just briefly like to point out to the court with regards to the state's response to the motion for bill of particulars. They're saying that there are four main things. The first being that the court is without authority to hear or grant the bill of particulars. They indicate that a bill of particulars is, and this is according to their own brief on page 2, paragraph 1, says that a bill of particulars is filed when a charging document fails to provide sufficient clarity as to the specific accusations against them. And we believe that this falls squarely within that specific statement. The indictment does not meet the basic requirements of Rule 7.
Yes, it does through the overt acts. It's very
There are
descriptive.
specific mechanisms to be used when filing these, and we believe that the bill of particulars is discretionary with the court, and given the gravity of the offense charged, the possibility of punishment, the finality of the punishment, that the state should take a second look at this, in that we believe that the state has failed to meet the basic requirements of Rule 7, where it must give a plain, concise, and definite written statement of the essential facts constituting the offense charged.
The overt acts.
Perhaps the reason that the state of Idaho does not have a rule for bill of particulars is specifically because of Rule 7, where it says that it has to be a plain, concise, definite written statement of the facts. The state's indictment has been debated. The court in argument from Mr. Wood has indicated that it had trouble reading through the indictment as well prior to making its final decision that the state was okay in doing what they did in a previous ruling. But we believe that it doesn't meet the basic facts or the basic premise of Rule 7. The second thing that the state has indicated is that it is untimely pursuant to Rule 12. And we would argue that based on the volume of discovery, the complexities of the death qualified counsel that are required, our team's preparation, the severity of the punishment, and the lack of prejudice to the government, we would ask that the court find that there is good cause to hear the motion today. I believe the court ruled in Mr. Daybell's motion that there was good cause to hear it, and the court did hear it. So we would ask the court to go along with the same reasoning that the court used in the Daybell hearing. The third thing is that the state indicated that it's a thinly veiled effort to obtain the state's trial theory and work product.
Don't talk about veils.
I would question that statement, indicating that I don't know that the state has or should have anything to hide. I don't know why that they're protective of their theory or of their discovery. It doesn't make a lot of sense to me. It looks like they're supposed to be the ones who are looking out for everyone's interests, including my client. They are the ministers of justice in this
she was a
particular realm of the law. They wear the white hats, and they prosecute or supposed to prosecute without passion or prejudice. We certainly do want their theory. The public is entitled to know what their theory is. Their theory should be fairly obvious. It should be
they endorsed and espoused religious beliefs for the purpose of murder.
Children and this other woman, and this is how we're going to prove it. That should be their theory. Their work product, they're indicating that we're trying to steal their work product or get into their work product. I think we went over in the last motion, the motion to compel rather closely what work product is. Rule 16 indicates that legal research, records, correspondence, or reports to the extent that they contain opinions of the prosecutor, that is what their work product is. Their work product does not involve everything. Their work product is very specific pursuant to Rule 16, and we would ask the court to require that bill of particulars pursuant to that, and require that they narrow down what they are arguing for this. The fourth thing, they indicate that the indictment is clear.
It is.
It is certainly not clear.
Yes, it is.
What the case law comes down to is saying that, and I'm going to quote a case here, State versus Harriman Garcia. It's 160 Idaho 643. It's a 2016 case. It says that basically what we're looking for in an indictment or an information is whether the pleading contains elements of the offense and it fairly informs the defendant of charges which must be defended against. The indictment is not clear as to what the charges are that need to be defended against.
Oh, yes, it is.
It contains the elements of the crime. It contains lots of elements of lots of crimes.
Yep.
Because that's what they did.
Another case, State versus Banks. The information may not merely state the general crime. Information is legally sufficient only if it contains a plain, concise, and definite statement of the essential facts constituting the offense charged in such a manner as to enable a person of common understanding to know what is intended in the charge.
And I'm common and the overt acts. Tell it all.
113 Idaho 54. That's a 1987 case. But we've gone over several times, Judge, that this indictment is confusing. The layers of alternate theories that are given the gravity of this case and the sheer amount of discovery that's been given. I know the state has argued in its motion to continue the trial that there was a lot of discovery. There is a lot of discovery, and that's why they were arguing for an October trial date, because they're not prepared yet, and that they, even though they indicated that they were prepared, they were arguing for an October trial date. And that even then, they were worried that it was going to run into the holidays or run into next year or the year after 2024.
My God.
I think that when the court is concerned about narrowing down the issue of trial and trying to keep this within the 10 weeks that it is set out, it should look to that and say, hey, gee, can we shore this up a little bit? Can we narrow down the issues a little bit? With these alternate theories, I know the state is entitled to do that, but I think that there's great discretion with the court in allowing the court to say, hey, listen, this is too broad. There are too many issues here. If we have to, on every witness, go through each one of these alternate theories, a 10-week trial may turn into a 20-week trial or a 25-week trial, and nobody wants that, Judge.
Do your job.
For judicial economy and for the other reasons that we've asked for, that the court narrow down the issues and allow us to prepare for a trial that we know is going to go in April and will extend into the summer, but hopefully we can narrow the issues down enough where we can consolidate some of that time frame. Thank you, Your Honor.
All right, thank you for the argument, Mr. Thomas.
Overt acts.
Bag of air.
Courts reviewed the response also filed by the state on October
5
6th.
minutes left.
And who's going to be presenting argument on this?
I will, Your Honor.
All right, Ms. Smith, if you'd
Overt
like to
acts.
argue in opposition, you may.
Thank you, Your Honor. I will not re-argue everything that's contained in the state's argument, and we did argue on the companion case, but just to briefly address a couple of points raised by defense counsel. In the state's response, we did discuss what the normal practice is for bill of particulars, and having come for a jurisdiction where those things occur, there is no companion Rule 7. And so Rule 7 in Idaho accomplishes for this court, and combined with Rule 12, accomplishes for the court and for defendants what defense counsel is attempting to ask the court to look at here. There is no authority in Idaho for a bill of particulars. The court
That's
is
right.
without jurisdiction to do it. And in fact, defense counsel have already raised very similar efforts, very similar issues in their effort to challenge the indictment that the court has already ruled against. And so while I applaud defense counsel's creativity and legal manipulations, in reality, there's no authority for the court to do this. I understand their vigor. I understand their creativity, but it's really about getting what the state's theory of the case is. And that's a little different than getting out what the actual charges are. Counsel are allowed to present their case in the way they wish. We're allowed to have strategy. We're allowed to have theory. None of that is discoverable. And so while I understand there is a lot of evidence for the defense counsel to go through, complaining about too much evidence and then therefore trying to attempt to limit how the state introduces that evidence and ask ahead of time what our plan and strategy is under the guise of a bill of particulars is simply not allowed in the state of Idaho. And for those reasons and for the reasons outlined in our previous motions, we would ask the court to deny it. We also had included in our request a specific request of the court asking, these are really rules that are best raised under Rule 12. And the court has imposed, and the courts have imposed time limits on the parties to prevent the situation where the court is continually litigating challenges to the charging documents up to and to the day of trial. We would ask the court, as part of its scheduling plan, for any of these sort of successive challenges to the indictment that are really thinly veiled efforts to dismiss the indictment, that there be a deadline for both, and it's unfortunate Mr. Pryor's here, but it was in both cases we made this request, that we gotta draw the line somewhere. We gotta quit challenging the technicalities and move forward with the evidence. So I would include in our request for denial, our request that you put some sort of parameters around these sort of successive legal challenges that are really best filed under the parameters of Rule 12.
All right, thank you for the argument, Ms. Smith. Any rebuttal argument, Mr. Thomas?
No, Your Honor.
All right, counsel, the court, previously on this motion, I ruled from the bench in the companion case. In this case, I'm going to take the issue under advisement to issue a written ruling, further review the case site that was provided by Mr. Thomas, in addition to potentially address the concern the state just raised on timing issues. So for those reasons, the court will have this matter under advisement and will issue a written ruling on the motion for bill of particulars.
Thank you, Your Honor.
All right. Counsel, anything else we need to bring up today for the state?
Not to the state's knowledge, Your Honor.
Anything else this morning then from the defense?
In rescheduling my motions regarding the constitutionality of the death penalty and the jury qualification, can I have a new date for that and prepare a new notice of hearing?
That'd be great.
Yes, Mr. Archibald, but not right at the moment. I am going to take a little time to sift through calendaring issues, and in short order, we'll reach out to counsel to get our calendars out in an administrative capacity to just look at what dates we have available coming up through trial and when things can be scheduled. So once we have those dates determined, then we'll let you know without delay when that can be reset.
Thank you.
All right, that'll conclude the proceedings for today then. Thanks everyone for complying with the court orders today, and we will be in recess.
We ain't seen nothing.
Well, what all y'all get out of that?
All right, we'd ask the audience to remain where they are until the defendant's been escorted from the courtroom, please.
She's probably stuck to the chair like one of those plungers.
Suction. Always bringing up old shit.
Right.
Seen nothing yet. So unique.
There's your little Stroud.
You ain't seen nothing yet.
We ain't. Look, well, here it goes.
Hey,
We
can
ain't
you?
seen nothing yet.
Right. Well, can you believe the state wanted they were saying they were ready for trial, but then they talk about, sequestering the jury, talking about DNA, one of 3 items of discovery's already been turned over, and all of that. They say they're ready for trial, though, Cresha.
They sound like a bunch of whiny ass people.
And then John Pryor said he wanted his. He wanted it way out there. He said October or even the following year. He said that, of course, he said he wanted severance, and he said he needed a significant amount of time. Well, what in the hell's this man been doing for 2 years?
Well, lifting the flask. Thought you'd never ask.
What's interesting, and I wrote this down. John Pryor said, "Well, Rob Wood just gave me today 115 items of discovery," and it's very interesting because then they talk about later on. They talk about there was 115 witnesses. Now, is that a coincidence, or was that what Rob Wood turned over?
I don't know.
And then
I'm
we
gonna have
get
to
into
look.
the Melanie P, Melanie Gibb, and Zulema stuff. I mean, come on. This is a confirmation right here, Cresha. Melanie P and Zulema are on the hot seat. They've got to turn state's evidence.
They better, because they're. Oh, I might have to stay away from the trial. It turns out I'm gonna need some bail money. I'm just saying.
Well, I can tell you this right now. Lori's been in jail, according to Judge Boyce, 1,022 days, and Chad's been in jail 912 days.
Well, if we knew when their execution date would be, then we could tell them how long they will be in there total.
Right.
We could sum it all up.
Well, I can tell you this right now. John Pryor's a whiny little bitch. I'm telling you.
Right?
He is whiny. He's talking about, well, yeah, Judge, you said that the state agreed finally to give me that second grand jury transcript, and I haven't gotten it yet. Well, I'll tell you what, just as Rob Wood said, there's nothing that the state is going to withhold that they're going to use at trial, or they'll get in trouble. There could be a mistrial. They're going to turn everything over if they haven't already turned things over. The only thing I see is the 1 out of 3 items of DNA evidence that's been sent to the state lab that hasn't been turned. 1 of the 3 had been already. So we know what that's about. That's that shovel and all that other stuff that pissed us all off.
Yep.
But ultimately, if you really look at the arguments today, the bottom line is Lori Daybell. Lori Daybell is the reason we have the trial date that we have. That is what Judge Boyce was looking toward more, because Chad had waived his right to a speedy trial.
Yeah. And I mean, can Lori go and do opposite of what she did? I always forget. I always get them mixed up.
If Lori's attorney came out tomorrow or today and said we want to waive my client's right to a speedy trial, then the judge would say okay, and then there would be more leeway. But because she has not, she's standing her ground with her damn ponytail between her head there, and hopping up and down. They're going to have it in April. And they're going to have pre-conferences, which will be scheduled before then. My hope is if in January, because I'll be there in Idaho from the 8th to the 15th, if there's any motion trials, I'll be there.
Man, I'm like, come pick me up.
Well, I'll definitely, if there's any motion hearings or anything during January the 8th through the 15th, I will definitely make sure that it goes to your channel. Definitely, 110%.
Yeah, Jen's done it, so I can show you. I thought that was very, very awesome of you. I'll go pick it with you. I know that's what you're going to do. Also.
Yeah, jury selection. He's talking about jury selection will be in late March.
Yep.
And I'm really excited about it. I mean, it seems the judge has really done his job. He is the administrator of justice. I really think he's done good. What did you think of Archie and them bringing up Melanie Gibb sent an email to Rob Wood, and Rob Wood sent an email to Melanie Gibb? Wonder what that was all about. Pryor's got it. John Pryor's got it. But Archie says he hasn't gotten it.
It was about emails. No, I don't know. I don't care. I know that sucks. I just haven't yeah, I have to absorb things, you know? Like I'll have to whenever we finish this live, I'm gonna do a I guess another live stream, but just the audio, you know, without
Right.
interruptions or whatever.
Well, I couldn't help it.
Well, no, me neither. I can't, and I couldn't mute myself because I was using my microphone. I usually talk a lot more mad.
What I get out of today's motion here, and besides the scheduling conference of our trial date, which is the most important thing, is that we got confirmation today that, well, we knew Melanie Gibb was at Chad's preliminary hearing testifying, but we didn't know for a fact whether Melanie P or Zulema was state's witnesses. They're state's witnesses. They are going to be in this trial. Now, what could we possibly theorize they're going to talk about?
They're gonna
Well,
lock
we'd
them
have to.
up.
We don't have Melanie P's interview with police, but we have Zulema's and Melanie Gibbs. So, I mean, they had to get their story straight, I guess,
If
and
they
get their
lie, that's all
and
they
get
do, anyways.
yeah, get their ass out of trouble.
I mean, I wish I could just randomly pull them up right now. All the word salad. They go, you know, y'all know. I mean, nothing but lies. Their mouths are open. They lying or omitting. Omission is it runs thick in this group.
Well, I can tell you one person I'm going to be researching, and I'm going to figure out what in the hell he's doing trying to make the state look bad. And that's that Brandon Hobbs, which Kathy says was the realtor. That flipped my wig. I was
Yeah,
like,
it's
oh
not.
my.
But then she researched, or you know, people were looking it up and everything. Thank y'all for doing that, by the way. Um, sorry, and said that he was I think I don't remember, a mitigation something
Specialist.
something.
So he's not the realtor that was with Chad and them?
I don't know, but I do want to know that because one of the last people to, you know, on the day that JJ was or whatever, you know,
Where
right,
Melanie Gibb and David Warwick couldn't keep their story straight on who
right.
was actually out at that property?
Yeah, nobody was watching JJ because nobody needed to watch
That's what
JJ.
I'm telling y'all. And y'all think I'm just crazy. I'm telling you, whether the state has a theory of the time of death of JJ, I'm telling you, it happened not very long after that last photograph. And it was during the day into the evening. That's what I think.
That's
But it could
trophy.
have it could have been overnight, but they started the process that day.
If they
And
were
we
even
just
looking at property, you know, there's a lot of code words going on in here, and y'all don't know the half of it. Yeah, and I don't know the half of it. I mean, we're okay. My head just spun around a couple times because I mean, I'm putting together right now. Uh, uh, since my internet's working great, y'all notice that? Yay! Laptop is good. um, I'm putting together a live stream, and it's about blood atonement and violence. You know, and well, I don't want to spark any fires, but um, and just how I see it. I mean, I'm gonna lay it out there, and y'all's heads are gonna spin. I wish I could just be blunt about it, but I really can't. It's not something I can really be blunt about. But I'm gonna try and put it together as best as I can, and you know, it is what it is. It's nothing I did, nothing you did, nothing anybody here did. It's what those two assholes did, and friends. You know, they did all this. If anybody wants to be mad at anybody, be mad at them. You know, because me, my family, none of our families, we didn't ask to be put in this position at all. I know I could think of 100,000 things that I could do instead of, you know, dealing with all their crap. I wouldn't have met you fine people though. So there's a silver lining. But I mean, there's nothing but code talk. I don't know if that realtor, I want to know, I've been wanting to know who that realtor is forever.
well, when you have this realtor asking Zulema's attorney or trying to get with Melanie P, met with her and the FBI agent / the state met with Melanie P in Arizona. This is what I got out of it. And Zuzu's, this realtor actually went to Zulema's home. Now, if he is a mitigation specialist for Lori, then what the hell? I mean, what is he trying? Mitigation means he wants to get something from Zulema that's going to make Lori look good. Okay.
Mm-hmm.
And the bottom line is he's confirming, he's confirming that she was in Rexburg, Idaho. He's not given the time frame, but I think it was not too long ago from what I understand.
From there. So, I mean, okay. I mean,
But Thomas is saying that the state is lying to them about that. But the state says, we never said that we didn't interview her. We never said that. What the state is trying to come across is if we have met with Zulema or Melanie P. or Melanie Gibb, we've turned over those statements that we intend to use at the trial, and anything else that y'all are fishing for, you're shit out of luck, because that's work product. That's theory. And the theory of the case, in my view, that the state has put forth in the indictment is that they endorsed and espoused religious beliefs for the purpose of murder. And then they quite clearly show through the overt acts, which are listed, down to Chad calling his wife Viola and every damn thing else.
Mm-hmm. They called Tylee.
I mean, how more specific do they want? They need to start by sitting down with that fat ass chin Klein of his, John Pryor, take a swig off his whiskey and say, why did you call your wife Viola? He's got to account for all this crap. And Lori, let me see what Lori's going to say about the fact that she kept collecting insurance money off her dead children and knowing good and damn well that they were in Chad's backyard.
The kids are safe. Yep.
I mean, they have no answers, Crescia. And that's why this trial is going to be so, it's going to clear away an evilness out of this world as soon as the adjudication process is over.
Amen.
We're talking, they're going to be slamming the doors shut on evil. That's what they're going to be doing because, as I've said many times, Chad and Lori are like demons in a corner, and they're cornered and they can't get out.
I agree with you on that. And my mom said, I'd rather be watching Dateline reruns as an anonymous person, never wanted or envisioned being in this story. Amen.
I just think I hate it for Kay and you and Larry and all the victims' family members. But I'm going to tell you what, it's been a blessing in my life and in other people's lives that we've got to know y'all. We would have I mean, I know it's hard to see anything good that's happened in all this when it's so sorrowful and hurtful and tragic and terrible. But I mean, some wonderful things have happened. And maybe they don't outweigh the pain and suffering that y'all been through, but damn, I love you. I love Kay. I love Larry. I love all these victims' family members because y'all are just like all of us. We're just people in this world. We're human beings with feelings and hopes and dreams and things of that sort.
And we love you too. And I mean, that's so like I said, the silver lining in all this is you guys just, there's no way. At first, I was like, oh my God, having to share or it's so public, it's so public and not everybody grieves the same way. Not everybody reacts the same. Everybody's different. You're the only you're ever going to be. Right. And so there's so many different personalities. There's so many different people surrounding this that, I think I just went off topic, but it brought me right back to where I always go, and that is to the victims. They get lost in this. They get lost in this.
I'm all for this. I'm all for this.
Look, I'm going to share something. Mom, it might make you cry, but look away. It's sweet, but just listen, just watch. Here we go. Never again. You know, goes back to the victims. Ugh. So, I mean, if that don't, that centers me every time. Every time. They don't get a voice in this. It's not fair to them. It's not fair to us who have to carry the burden and basically get the life sentence. We're sentenced for life for sure. I'm just ranting right now. I'm sorry. I don't know.
You have a right.
Mm.
And I want to say this. Who said Kate said, I'm sorry we met this way, but I have learned so much. And we have to hold on to the good things that's happened, even though we got to deal with the bad things. I'm not downplaying the bad things are way worse if you really think about it. But there's so many wonderful things that's happened too. And we have to look at those wide-eyed.
Yep. Just watching that, it reminds me, it's the humanizing them because they were so dehumanized, calling them zombies, dark spirits. I mean, y'all have seen the text between just what was released from the Chandler um docs. I mean, there's so much more. There's so much more. And like you said, they're demons in a corner. And I just picture them going, like they have nowhere to run. All they can do now is it reminds me of those monkeys that throw poop at each other. That's what it reminds me of. I just picture them as monkeys throwing poo at each other. And
Well,
we're going to need a hazmat thing.
When we can witness you, Larry and Kay, and your family rising above things, like Kay's saying right here, there's always good, even in the most horrific situations. We're grateful for the wonderful people we've met and learned to love. It counterbalances the depth of evil we are all witnessing. And, when I just knowing that I was able to even hear that or hear anything you have to say, Crescia, it's to me, it's very humbling. It's very humbling, and it's a blessing. It really is. I know maybe y'all don't see it. Maybe I don't know
We
how you
do.
see it other
We
than what
do.
you
I
say.
do. I do. I see it's reality. That's just that's what it is. It is reality. Um, but yeah, I forget what I was even trying to say, and then just they popped in my mind, and it just made sense. And hey, Ash, love you, mwah. Miss you. Actually, I have video of Ashlyn at Thanksgiving, and I was like, say hi to KJ. I still have to upload it, okay, to share it with you. And anyways, I was like, Ashlyn, what are you supposed to be reminding me to do? And she was like, I don't know. She had that I don't know face, and I was like, oh, KJ, she's not on my butt, reminding me that we need to go to Tennessee. And she was like,
Hey,
it's
I
just a
told
deer in
them when I
headlights.
left there, I said, you need to ride your mama,
I had to remind
ride
her.
her all the time until she has to give in. Because our door is always open, and your family, we will always welcome you with open arms. If you just called me up one day out of the blue and said we're coming,
I know
we
that.
would roll out the old country girl and country boy carpet for
Mhm.
you. We would.
And it's the same. It goes both ways. And so this is God's army. I mean, even if you don't believe in God, I mean, that's exactly how I see this. I can't help it. It's just, you see I see all your faces, when I look behind us. Like, I look back and I just see every one of you right behind us, like in lockstep, like we're going together. That's what we've been doing. Justice through understanding has been more impactful than I ever thought. When you said that phrase, justice through understanding, I was like, oh, okay, D to D. And then it got me. I was like, okay, yeah, justice looks like it looks different to everybody.
Yes, it does.
Everybody's heaven, everybody's hell, everybody has a different perspective, a different idea of what I do or you do or everybody in here. And so when you bring all that and everybody brings something to this table, right? And that's the networking and everything. It's so awesome, and it's so comforting, and it's comforting. So to have you guys here means the world. Not just to me. I don't speak on behalf of my family, but they've said it, that you guys, y'all keep us moving forward. Y'all keep the breath in it. um,
Your family is an inspiration to all of us to see your, just the realness, and knowing that there is no way that I don't know that I could. I mean, I don't think I could if
You
something like
did.
this was to happen to me, that I could go on a platform and just explain these things that you're feeling and thinking and doing, and allowing people into your heart, and allowing people to see it, and know that those people, when they see that they themselves can open up about themselves. And
Please.
it's a beautiful thing. It really is.
It's terrible to hold it all in, It's I think I would have imploded by now, Oh my gosh, nobody to talk to. Coronavirus was happening. Um, I mean, everything shut down. And had it not been for that horrible thing, just, the coronavirus, I mean, that's terrible. But the silver lining in that was everything moved to Zoom, and everything um, started showing on, um, on the internet, and you could just have these things where, you have a live stream and everybody comes, and we talk and we exchange ideas and theories, and, um, talk about the weather. Well, the weather, talk about, everyday things. And so, I mean, in the coronavirus, I have to say that the blessing in that was me being able to stay connected and engaged in this case from different creators, different perspectives. That's important to me. Like, to just level myself out, I'm like, yeah, I didn't think about that. Or, you know, um, just a different take. So you can see all sides, because I have no say in this. I don't. All I have control is over myself. and that's, touch and go. But I mean, that's all we can do.
Well, let's just not forget this, because I know you're not going to bring it up, but I will. I don't have a problem doing that, because I know I'm doing the right thing. And that is if anybody can monetarily help Cresha and get,
Thank
with trial costs or anything like that, or if you feel better, just going to the merchandise shop,
you.
looking through that, maybe you'll find something you really want. Just in support. JJ and Tylee, Tammy, Charles, Joe T-shirt, whatever it is. Um, I'm telling you that it's the best that anybody could do. And, I hope that everyone will consider that, because I see time and time again, all of us at some degree or another helping support Cresha.
Thank
The
you.
monetization is something she doesn't feel comfortable with, but I feel like she needs to understand that this is what needs to be said. And we've got wonderful people that are taking time out of their life for nothing at all. You got Leanne Ferguson, you got Jennifer, you've got others on here, Kathy, Mama Bear, all these people that take time out of their life because they love Cresha. And I know all of y'all love her too. I love her. And I want to be able to look back on this one day and know that it never ended as far as our community, that it's just stayed as strong as it ever has, even after convictions, even after all of that. And knowing that, a victim's family member was shown true love,
Yeah,
lasting love, unconditional love. That's what I'm here for.
I
And
love
I'm
it.
here to get justice through understanding with all of
And
you.
that's so awesome, KJ. I mean, you're my biggest cheerleader. You really are. And I know you do it because you do love. and you're a realist also. You know what it's going to take. And I know that too. It's just feels weird. Feels weird, you know? I struggled with the monetization thing, but look at all the YouTube creators, you know, who this is some work. Let me tell you, this is some work. Holy crap.
Well, if
You know?
you put the work aside and think about just the emotional roller coaster you're on, and on top of it all, you're doing all this research and work.
Yeah.
You know, that's a lot for anyone to take on. You know, I've not seen you take too many breaks.
No, I don't. I don't know how. And not yet. You know, I know that when my intuition, when my gut says, "Oh, okay," you know, then I know that's when it'll be time to move along. But I mean, I've never had anything just grab me, um, keep me engaged for so long. I'm in it. I'm in this. um, no, I'm never gonna stop, you know, until I get answers and get justice through my perception of what it looks like through understanding, you know.
Well, you can't know something that you don't understand, right?
Exactly. And I mean, there are so many things that I did not know that I didn't know. I didn't know that I did not know them. And there's so many more things out there, not just bad, all kinds of things. There's so much to learn, and it just reinforces, you know, do your own research. It's very important. Don't just take everybody's word verbatim. Don't just go with the flow, you know? You
Well,
are
anybody
kind
can
of weird.
do that anytime. Anybody can watch a trial, a criminal trial. Anyone can read a storyline of what happened.
Mhm.
But we're talking about the real reality of a victim's family member
Yeah.
and her family, and y'all's journey to get
Yeah.
justice for your loved ones. And
Yeah.
that to me is epic. It's something that stands alone. And no one else is going to be able to provide that genuine content. Nobody.
Right. And I'm glad to share it, you know. I do the best I can, you know, with what I got, with what I have. But anyways, y'all want to see this? Y'all want to see the duo walk out? Look at
Oh,
her.
her hair's getting darker like my wig, y'all. It's
Her
getting
hair is
darker,
down.
just like I told y'all. Yeah, that's why I got that dark wig.
Ugh, look at that. Ugh. Oh, Frumpty
Can you
Dumpty.
believe it? Was she looking
Okay,
at
y'all
his
ready?
behind?
Uh-huh. I'm up. Oh, it's snowing too. She hates cold.
Oh,
High five. High five,
oh
mom.
my gosh! Look, she's
Whoop,
curled
whoop.
her hair. No
I'm gonna go
ponytail
eat
today,
gumbo.
y'all.
All right, I'm gonna
No.
push play. Ready?
Royal Theaters has been proud
No
to
way.
call the Bank of Commerce our business partner for the last 8 years. We built our entire business on family entertainment.
Great.
That's why they're the only bank we'll ever need. The Bank of Commerce, our bank of a lifetime.
Goes Pat Chin. Oh, there she is. I think it's sinking into her. What do you think?
I think she's
I think it's sinking in real quick with her. I think she realizes Chad don't want none of that dang yoga pants stuff anymore.
I hope it's all reignited. I hope they're in love again. I hope.
Oh, don't do it. There ain't no such
All right,
thing as
one more
love with
time.
them two.
One more
You're
time.
talking about in lust. Because there ain't no love
James
in that.
the Lust. Yeah.
They're
James the
legally
Lust.
married. That's her spouse, and that's his wife.
Mhm.
They can enjoy
They
the hell
sealed
out
up.
of it as they sit in the damn seal prison. They couldn't get out of there fast enough. They just couldn't get out of there fast enough. Here she
There's the kids,
comes, Miss
Lori.
America.
Where's the kids?
Right? Man, I wished I'd have been there. I would have been yelling. I would have been yelling something like, Lori, where's your yoga pants, Lori?
That's a
Are
good
you
one.
going to grind on Chad, Lori?
Oh, I'm sorry. Yeah, I hope Mom said I hope she's freezing her ass off. You know she is. Well, I don't know. His loin fire might have heated her all up, and she's just gonna be grinding on, scissoring.
You know,
or
and
something.
none of
Sorry.
us, none of us are ever going to know what this woman thinks. We all think
Thank God.
right. What I'm saying is it'd be great if we could say she sat there today by him and realized this is what I murdered my children for.
Thank you.
This
Thank
is what I'm sitting here and I murdered my children for this.
you.
I mean, or him looking at her and going, well, I ain't gonna get to tag that again. I ain't gonna get to throw any nickels at her, if you know what I mean. She
Oh
ain't gonna be
man.
no spread eagle for me anymore. I got to get used to Bubba in prison.
Right? He's already used to him by now.
I'm sure,
Sure.
because prison life ain't gonna be easy for neither one of them. And I'd love to say that they both think about what they've done. Chad to his wife, Lori to her kids. I'd love to think that they have some kind of remorse, but she doesn't look it.
Only for themselves. We know that, right? I mean, that's a narcissist. They're all about themselves. They deserve each other.
I'll tell you the one thing that I will never forget, and I know my husband Wayne will never forget, is when Larry was speaking with Nate that one time a while back, and he
I
said,
have it right here.
he said, she thinks she's Miss America and all that. I'll never forget that as long as I live.
It's true.
I mean, I just, it's just incredible the restraint that Kay and Larry have had, along with you being very
Yeah,
measured.
but I'd have stuck my foot out that first time. I don't know how Mom and Larry did it, and Brandon, like all 3 feet would have been out, pow, tripping her ass. Just saying.
Well, all I know is that y'all have somehow, and I have to believe, I mean, this is just my view, that by the grace of God that y'all have rose above a lot of this. And I know you'll have your own personal feelings that you know are going to keep private within yourself that hurt you and stuff, but
some things we don't even know yet, Yeah. Mom, if it's over, okay, if it's over 80 degrees, she's freezing, no doubt. Yeah.
Hey, I know she's not getting the Hawaiian treatment over there in the woman's jail in Madison County. I've researched the jail over there, and I'm telling you, the woman, she will never see a Hawaiian shore again, and she sure as hell won't be wearing one of those leis. And Chad, he ain't gonna know what a ukulele is after he gets to prison.
Battery 80%.
Right.
Connected to.
Okay. Here's that.
I thought it was very good hearings. I appreciate the judge's rulings. I think he's more than fair. I appreciate the court's position in this, and I certainly appreciate the state's position in this. And, what this turns out to be time-wise will be. And we've waited 3 years, and another January the 17th, that's fine. If it's July 17th, that's fine. We're going to be here. We haven't walked away. We intend to follow this through, the good Lord's willing. And I just appreciate everybody involved in this. As I've said many times, this is like our second home. We love Rexburg. We love St. Anthony. And we love the state. It's just a marvelous state. I love JJ and Kylie Moore, and I miss them terribly. My little man, is 10 years old, and there's not a day goes by that something we don't see reminds us of JJ.
There was another incident of a family taking their children, and they've been unaccountable for just very recently, as you know. And I can tell you that Kay cried for 30 minutes nonstop, just having to relive this from what we've gone through. And it hurts. It really hurts. I hope those children are found. I hope that a right decision is made.
They were.
I wish there was so much more that was available to grandparents' right. I think it's a big area in the United States and a big area in our state of Louisiana, and from what I've seen here, that's an issue that needs to be addressed. You know, we all make mistakes. Everybody does. I don't care who you are. Everybody makes a mistake. But life is pretty simple. It's a choice and a consequence. And the choice that family is making can be a horrible consequence. We're living it. We've been living it for 3 years. So in regards to the other family, I really hope they come to their senses and the right thing is done. For the grandparents of those children, we absolutely understand. We understand more than you will ever imagine. And so I pray that it comes to a happy conclusion.
Larry, what do you want to see most right now? What do you want to be able to do?
You know, at this point,
all he wants for Christmas is to bury his grandson. I can tell you that right now.
I want what is right. And I know that's an old adage, but I want what is right. But on the other hand, these continuous filings that the defense is doing is a stall tactic. I don't think there's anybody alive that does not recognize that. And but they have to be treated fair, and we understand that, and we accept that. But I would really like, first of all, a fair trial, and give us our grandkids. You know, I mean, whether it's they give them to us, whether they give them to their brother, you know, let us conclude this, and then the trial is going to be a trial. There's no doubt. Whether it's a bench trial, whether it's a murder trial in Boise, it's going to happen. There is no doubt about that. And so all we want to do is at this point, John, is to simply continue to move forward and let the state prove what they prove and let the defense file what they file. But take some consideration and let's just all keep moving forward.
You want to be able to take care of those kids, finally.
John, if there is anything in this trial that I want more than that, I can't think of it. And the outcome of this trial is what the outcome of this trial is going to be. But I think at this point, our family, and that includes our friends here, it includes our friends from all over the world, just give us an opportunity to close this item, this one bit of stress for us. And now, can we wait? Sure we can. We waited, 2.5 years now? I think it's been, about 2.5 years now. And the children are still in the freezer. And all we want is a little bit of closure on that, so that at least we have a grave site, so at least we have some closure on that. And that's important to us. It really is.
Yeah. So, I mean, I was thinking about that the other day. I was like, I ought to do a live stream and just do a little bit of research before beforehand, on murder victims. Is it normal? I didn't even know. It's not like I've never been through this before. My family hasn't been through this before. And I mean, there's so many moving parts. You're just like, there's so many distractions, right? And I just stuck it in my head that I was like, well, they'll release the kids' bodies whenever it's time, right? I just want them to have everything, so they don't have to disturb them again or whatever. But then, once that came out that, Mom and Larry came out and said, "Hey, we want to bury them." And I was like, "Whoa, holy crap." It just, it shakes you back to center and you're like, "Whoa," you know, everything gets caught up in all the poo throwing contest, and the victims get lost and all that. And it would mean the world to be able to put those babies to rest, to give them a proper burial, to give them proper memorials, to have them, to where people like yourself, y'all can come and mourn with us and celebrate their lives with us. They deserve that much. That's the only say so we have in this, really. And then we don't even have say so over that. So it just feels like it's very easy to become or to remain or whatever, to allow Lori and Chad be our abusers, to continue victimizing us, right? They took all the control into their hands, and here we are. And so because of what they allegedly did, we're the ones here left to carry the burden,
Well, you've always held yourself in such a good way, Cresha. I will say that I don't plan on ever saying the word allege. I know you've got to, but I'm not speaking for difficult research. I'm speaking for old KJ. Those two people are guilty as hell, and they've done enough damn damage.
Yeah,
they've done enough damage. Let the state do their job and release these bodies, because
I mean, what else can they take? It's like, what do they, I don't understand that. And so I don't know what, right. I don't know. And it's not really a conversation that I've just like to bring up when I went to Thanksgiving. That was the best Thanksgiving I've had in years. I hate holidays. I hate them. Anyways, it was good. And so you don't want to bring all that up. I talk about this. I think about this. I research this 24/7. And so it was nice to live in the moment.
Well, when Wayne and I came down there to visit y'all, did we talk about it at all when we were in the backyard at the Crawfish Bowl? No, we talked about just laughter and having a good time. And Wayne learned a lot from Larry, and
they were like two old friends chewing the fat.
I'm telling you, Wayne, every time he hears some news, he'll come home and ask. The first thing he always says after I give him the news, like today, I told him, I said, we got a trial date. I called him. He was on one of his job sites. First thing come out of his mouth every time. Have you heard from Larry and Kay? What has Cresha got to say? And he really, it bothers him. And he's a really old fashioned, down to earth person, but it bothers him.
It's just like Larry. I swear. How many of y'all would, I mean, I've thought about this, but I've got to propose it to Larry. I still haven't, because everybody grieves in their own way. I don't think of all these things. There's so many things that I want to ask, but I've heard him mention it like 3 different times. And so I was like, there's a way that I can set him up where he'll come on difficult research, but have his own little corner. You know what I mean? Like him, where he can just do his own thing.
Yeah, at his
And
own pace, if he
Mhm.
feels up to it, he don't feel pressured to do it or anything.
Right.
He wants to, because I'm gonna tell you what, that's something I can say about Mr. Woodcock, Mr. Larry Woodcock. He has a lot of wisdom to share with so many people. We've all witnessed it. We'll continue to witness it. I think he thinks before he speaks. I think Kay is eloquent and beautiful like
Mhm.
you, and y'all have your own distinct personalities. But believe it or not, girl, you and your mom are a
A
lot
lot
alike, in
alike.
my opinion.
I know. I know. And I'm okay. I'm okay with that. A lot of people are like, yeah, I don't want to be like my mom, but I do. I look up to my mom
I'd give
big
anything
time.
if my mom was here today. I would
She's
give
strong.
anything.
I know it's coming up on the year anniversary for you. Um, don't think that ever leaves my mind. I do. I see all the people in the comments right now in the chats. Y'all's names are familiar. I see them. I know you. It's like I know you. I just don't know your face. And there was a lady that came in here earlier, Teresa Fountain, who one of her family members was murdered in Indiana, and she was flying there tomorrow. And I'm just like, oh my! I couldn't say anything because the hearing was going on. But oh my God, I'm so sorry to hear that, Teresa. If you're still here, my heart, my prayers, every love and light. May God be with you. Because you're gonna need them, and then we'll be here. We're not going anywhere. So it just sucks.
I'm just thankful for all these beautiful people on here. You got Kathy, Small Fries, Just Me, Missy Bancroft, Rowan to You, Sugar Butt Starburst, Sugar Magnolia, Who Said Cat, Diamond Eyes, Jorn Holmquist. I think I'm saying that right. Sherry Gilson. You got Leanne Ferguson, Human Animal. You got Dee Hutchinson. You got all these beautiful people on here, and I see them
Man,
time and time again.
I know. And across other channels, because we're all looking, we're all researching, we're all trying to find justice through understanding or understanding justice. We have our own way about it. And there's so many different interesting perspectives. It's just awesome to have you guys.
Krish, I had a real quick question, and I guess I could have probably just texted, but I was curious. That memorial that was set up near Chad's, it was on his fence originally, and then it moved to a neighbor's. Am I correct in that?
Yes, because John Pryor allegedly, John Pryor, the Chad's property was signed over, Chad and Tammy's property, I'm sorry, was signed over to John Pryor, to secure the rest of his defense. He should have ran out of money like 18 years ago. But anyways, and so Joe Murray allegedly and one of the Daybell kids, they took it down. And
What did they do with all the stuff?
The Prices live across the street. They're the ones that saw the fires burning, and things like that. Actually Chad and Tammy's land now, or the property where the kids were buried, that was actually owned by the Prices. It's a larger family, and Chad and Tammy bought it, and so I want to say his name is Matt. Is it Matt Price? Matt and Reagan or something? Oh God, I'm gonna butcher it up. But yeah, they offered to have a memorial there, and it's right across the street, right there. You can still see it. The first time I went was in January of 2021, whenever Garrett Smith and Mark Means and John Pryor were trying to get Rob Wood kicked off the case. Lori was supposed to have a hearing. I think it was January 4th or something. And me and Mom had planned to go, and then that they vacated her hearing or whatever. And then, so we decided to go ahead and go. And I'm glad we did that because it really did just, it helped me. I needed to be there. I needed to view it. I needed to walk in where they walked. I needed to just see it with my own two eyes. And I mean, the way I saw it, in the helicopter with Nate Eaton and everything was so different when I actually saw it, because it was white. It was snow white because it snowed, and I mean, it was beautiful. And they had taken down the decorations on that memorial fence. I didn't know this because I live in Louisiana and we don't have these kind of problems, but they have snow plows that go through there. So they took, them down, so that the salt and whatever, so they wouldn't get damaged. And some people like, Megan Music, Karma, I don't remember I can't, everybody's names, y'all know who you are, but they revamped a lot of the teddy bears and just repurpose them, or repurpose them and sent them to my parents, and just really awesome, amazing, beautiful sentiments, and so when mom brought me to go see the fence, there was no really memorial fence, and I was like, oh, okay, and I had some family rosaries that my uncle had given me, and there was like snow built up on the pole or whatever, the fence post or whatever. And I'm 5'3". I did a run and start, and I climbed up that snowbank, and I wrapped those two rosaries, and they hung on a rusty nail. I don't know how I did it with one try without falling or, making a fool out of myself. And,
That's
and
beautiful.
they're still there. And I have bracelets that match the rosary. So I don't know. It's just, it was very light to carry in an airplane, I mean, it was, anyways. So whenever I went back in April, when she became competent again, or the first time, allegedly, I got to see it without the snow. I got to see the fence. Janine, she really keeps it up. She's amazing. Rexburg, they're amazing people there. And
Maybe
they
I'll
have to live with this too.
yeah,
And
maybe I'll meet her when I'm there. I mean,
you know,
we're gonna go up there and we're gonna check on things, and it's all gonna be for your channel. Wayne and we want to get an
I appreciate
environmental
that.
view for everyone, and if it's 5 foot of snow, we don't care. We've already ordered
Mhm.
snowshoes and everything. We're
Oh,
gonna,
really?
yeah,
Yeah.
we're gonna January 8th through the 15th. We're going, and
I
hopefully they'll.
swear, if I could get a plane ticket, I'd be right there with you, because I was like, oh, yeah, I want to go. I
I'd
mean,
love
I
you to
don't
be
know.
there. I'd love you to be there. I'd love for any of you to be there if y'all
Yeah.
wanted to. But it couldn't have been past you when you went there and there was snow on the ground. Do you remember January of 2020 when they
Yeah.
did that first search warrant?
Do y'all remember whenever Mom and Larry's documentary came out about, uh,
Yeah, and that was before
Tuesday?
they found the
Do y'all
kids.
do y'all remember whenever they pulled up and on the property, or on the road in front of Chad's house,
Yes,
and Larry said, what if they were right here, or
I
something like
remember
that? And I
that.
was
That
just
puts a
like,
chill
I
up my
mean, it
spine every
right?
time.
Oh my God.
I mean, that just made the hair on the back of my neck stand straight up
It's
when you
still,
said that.
yeah. I mean, parents know, grandparents know, when you love somebody, especially children, the innocence is there. You know, the kids already grow up way too fast, and time, it gets, gets out of it, just goes. It really does. I used to look at people like they were crazy when they were my age, saying, you know, just don't, just be a kid, oh, whatever, old person,
Well,
and
well,
I'm just like, wow.
speaking of time, now it's going to go by so fast, Cresha. It's April the 3rd. I
Mhm.
promise you, girl, they're not going to move this trial back. And it's going to go by so fast. And it's so much better knowing now And I'm so thankful and am grateful because I know that y'all been sitting basically holding your breath for 3 years. Now you can take a exhale, inhale, you can breathe a little bit before this all gets started, because you know and I know, Crescia, there's going to be things in that trial that I'm really concerned about. I mean, I don't know how y'all are going to be able to get through it. I know y'all are strong, but there are things that even I'm going to have to walk out of the courtroom about.
Right. And I mean, that is the control that I do have over myself, right? I don't have to sit there and watch it, but knowing myself, I just kind of plow through. But I don't know. I that's one thing I cannot for sure say, hey, yeah, I'm going to stick it through. Or like I said, I'm going to try and bring as much of my perspective and share it here from the trial, but again, I don't know how I'm going to feel on any given day, or, I'm not one to just bust up in my parents' face, with my phone. And that's just not me. I'm not invasive like that, but,
well, I can
I
tell you
will
this.
share when I can and what I can, and as it comes, I don't know. And
Just remember
they'll do the same.
this. Just remember this, Crescia. Once you see something, you can't unsee it, honey.
No,
And you need to think about that. You
I
really
do.
do, for your own sake.
I do. There's stuff I've heard stuff yeah. And again, that was me just trying to be protective. I don't know how I got this idea. I was just like, oh yeah, I'm just going to go learn everything and know everything. That way nobody can just say, hey, did you hear about da 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 da? And I get sucker punched right there again. Not. It's by Lori and Chad, the sucker punches. They were really good at that. Still are. And I just didn't want to be sucker punched with information when it's there for everybody. I just wanted to get to it before anybody else can. And that way, in my mind, I was just like, and then I can protect my family. I'm just going to know everything I can know about it. And then, well, it really does mess with your with your mind. It really does. It messes with you. CPTSD is a real. There's things that are triggering. Again, I have free will. I can X out of here if somebody's making me, saying stuff that makes me feel. I know where the door is, and I'm not scared. Of backing out. That's the power I have. So, we'll just see how it goes. But I do, KJ, and thank you, for saying it here to me now. Just
Well,
reiterate.
just keep this in mind. We both know, Crescia. We both know that Chad and Lori thought that they were all powerful or whatever. They had all these special abilities. They thought they were elite. They thought they were better than people.
Yeah.
Now they got to sit at the defense table together, and they are going to see revealed right in front of them how
Yep.
absolutely disgusting and nasty they are. And to know that they've got to know other people in the courtroom are seeing that and knowing that they were the reason for it, and they can't hide behind this bull crap of priesthood, priestess stuff, and
Veil is
all that
torn,
crap.
babe.
It is bittersweet, but I'm telling you, they are going to hate every moment of the trial. If they think they're going to hate life in prison or death row, that's nothing compared to having it all laid out there. Pictures that I'm not going to look at. I can assure you that, of the autopsies. I'm not going to look at it. I don't know about you. I can't speak for you or your
I don't
family,
know.
but I'm
No.
not,
I
because
don't know
I
how I'm
can't
gonna react.
unsee some things. Once I see it, I can't unsee it, and I choose myself just in my own
That's your
heart.
control. That's your control, right?
But these two
You
people
know
are going
you
to
more
be
than anybody.
forced. I mean, they could put their hands in their head all they want, or lay their head down on the table, or look away all they want, but they know what they did. And they're going to have to realize that there are people out there in that courtroom, along with everyone in the state of Idaho, here in the audio, because unfortunately we're not going to get a camera. All these
Allegedly,
people
I
in
don't know. Y'all
Idaho
need
and
to
all
go.
over the country and the world are going to know how truly diabolical and evil these two are.
Sign the petition. Sign the petition. That's where your power is. Sign the petition so we can present it to the judge. I mean, I haven't tried asking. I don't know if my parents have asked. I don't know. Um, I'm not nosy. I like to dig.
Missy
You know?
Bancroft, the judge is not going to sever this case. He is dead set on them being tried together. This is a conspiracy case. It is the perfect case
Well,
under
no.
Idaho law for them two to be sitting at the table together. There's not
Yeah.
going to be any more of that. And the state brought it up today. They're tired, just as it's interesting that Larry brought it up months ago about we're tired of all this over and over again, these
Yeah.
stall tactics. The state has made it clear to the judge, put it in your ruling. We're tired of these debates. Let's get on with it.
Yeah. Let's get it on. That's all
So,
I think.
folks, I love you.
What do
I'm
y'all
gonna
think about? Yeah, I want y'all to what do we do our live stream Sunday about? Because I think the following one is when I'm gonna do the one about the blood atonement, just about how I'm gonna bring proof.
well,
Can't prove
I
it,
can
but
put on the community on KJ and the Rays community wall a question about that,
think
or you can
again.
put it on your community wall
Or
and
both.
let everyone on here decide what we'll talk
That's
about
what
on
I'll do.
Sunday.
I'll put a poll, and I mean, if y'all want to talk, let this sink in, let this hearing sink in. Let's think about it. Let's do some research, because that's what we do. We sleuth, and let's figure this out from different angles, from everybody's angles. And you know what? Let's not do a poll. Let's just come back Sunday and talk about this
Yeah,
today.
I think it's important that everyone on here, if they're willing, to go and listen to this audio again.
Yeah.
Listen to it and home in on things that you find that are important, things that have triggered things in your mind that might lead you down a road of
Mhm.
discovery to get justice through understanding. Your perspective
You're
is
welcome.
your own, and if you'll share it with all of us, I mean,
We appreciate it.
I would be honored. Be honest with you, I'd be honored.
All the time. All the time. I'm honored. I am. Thank every one of you for being here. KJ, thank you for being my legal analyst. You serve it up. Kathy, you too. I love you. Thank you for everything you do. And the people don't see it, but oh my God, I can't wait to hug all their necks. Everybody. I can't wait to see everybody and just and heal. It's time to heal.
Yeah, well, I done made it clear on my channel that if at all possible and things go the way they need to go, Wayne and I will be back down to Louisiana sometime next
I
year.
heard that, and then I was like, come on, you don't ever even have to. You can pop up here anytime too. You're always
Well,
welcome here.
we'll
And
pull that dang RV of ours. We love our RV, but
I'll go stay in. I'll go in your RV too. I already
oh
did.
well, that'd be great. You're welcome to. We'll blow
Right?
off some steam. But
Oh,
anyway, I love you all. Thank y'all so much for all y'all do.
mm-hmm.
Thank you for allowing me, Crescia, to come onto your platform. If
Thank
I've
you.
said anything that's derogatory or anything, it does not reflect on difficult research. It's just old country girl with common sense. And I love y'all all. And Crescia, I'll get with you. And Kathy, Leanne Ferguson, Jennifer, all the
Trace on the case
yeah,
and Beach Bum.
and
Thank
all
you.
those that donated. Thank y'all so
Thank you.
much. And please consider donating if y'all can. You can go on difficult research, and there's links there that you can help Crescia get to this trial. And
Thank
I
you.
love you all. And
Thank you.
keep on looking.
Thank you. I love you guys. Thank y'all for being here. I'm gonna end this one, and then I'm gonna do, I guess, a live stream just with the audio. I'm not gonna go on, nothing like that. And so I don't know how I'll do there'll be a chat if I do a live. I don't know. I gotta figure out all the details. And yeah, it'll just be the audio. So share it out. We got to build this platform. It's theirs. It's Tylee, Joe, Charles. Oh my gosh, let me say them in order. Tylee, JJ, Charles, Tammy, and Joe. Justice for the victims. At the end of the day, that's what it's about. At the end of my life, love is going to win. That's all that's going to be about. That's what matters. we got to pay it forward. So build this platform. Let's help other people. Get us in a position where we can help other people. I'll do whatever I can. Thank you so much. Thank you, Who Said Kate. Thanks, Jay Hughes. Thank you. Thank y'all for being here. I love you guys. And I'll see y'all Sunday fun day. All right. I got to find the end of the broadcast. Bye, guys. Thank you.